Time now for night courts. The Cleveland Indians thought they put controversy over their name behind them in July when the team announced it was changing its name to the Guardians. It turns out there is already a Cleveland Guardians. It is a roller derby team. And now that team is taking the baseball franchise to court, arguing Cleveland cannot have two teams with the exact same name. Meanwhile, the baseball team says doesn't see a problem. The two teams should be able to operate as is. Well, at bat for us tonight, data privacy specialist and attorney Sarah Gounder, along with criminal defense attorney Bob Bianchi. Welcome back, you guys.
How you doing, Shannon?
All right, we're going to start with Exhibit A. This is from the complaint by the roller derby team. They say two sports teams in the same city cannot have identical names. Major League Baseball would never permit Chicago Cubs lacrosse or New York Yankees rugby teams to operate alongside its storied baseball clubs, and rightly so. Confusion would otherwise result. Imagine seeing a New York Yankees shirt for sale and buying it. Which team did you just support? Sarah?
So I think this is going to come down to two things, damages and usage. So when you talk about damages, the Derby team actually experienced an uptick on their website and social media pages and their profits on merchandise because of this name change. And when you talk about usage, this is actually coming down to not federal trademark law, but common law itself. And that's important to talk about because they're going to likely point to their use of the name back in 2013 to now, but where the baseball team is going to have their strongest argument is in the last 2 years, Shannon, because they were not using their social media, they were not using their website, and arguably that would have been the most important time for them to do it during COVID.
Okay, so let's get to Exhibit B then. This is the Cleveland Indians, soon to be the Guardians. Their statement: we have been and continue to be confident in our position to become the Guardians. We believe there's no conflict between the parties and their ability to operate in their respective business arenas. Bob?
Yeah, Shannon, of course they're going to say that, but it's ludicrous. The bottom line is that the clevelandguardians.com, all their social media platforms they've been using, they have been open and notorious under trademark law for over 7 years, and with due respect to what Sarah is saying, they have gotten hammered. Their website crashed because people are going on there thinking that it's the baseball team. Merchandisers won't merchandise for the roller derby team anymore because they feel like they're not appropriately using the trademark when it's the other way around. They've had a lot of goodwill lost, and their social media rankings have gone way, way, way down because it's being consumed by the baseball team, which has not even yet started. So their argument is very clear. We were the first here. The first has the right to the trademark. And then what does the baseball team do? They go to some island I never heard of on the Indian Ocean on the east coast of Africa to file some paperwork in order to try to support their claim. But that is not the most dubious and deceitful thing. It's consciousness of guilt right there. The roller derby team, they're getting shafted with this, Shannon.
Okay, Exhibit C from the complaint by the roller derby team. It is inconceivable that an organization worth more than $1 billion and estimated to have annual revenues of $290 million plus would not at least have performed a Google search for Cleveland Guardians before settling on the name, and even a cursory search would have returned plaintiff's website, clevelandguardians.com, as the first hit. We'll give you each a brief final argument, Sarah, and then Bob.
Again, it's going to come down to damages and usage for the baseball team, but really quickly, it's really interesting to see both parties are not really talking to the media about the lawsuit, and I think that what's happening probably behind the scenes is they're working out a deal instead.
Bob, you think so, a settlement?
They're going to look for a settlement, but the other thing that shows it's really deceptive too, the baseball team asked them for their logo, and they actually went out, and that's another thing they put in the complaint, with all the money they have, they came up with a graphic design of a G with wings, very similar to the roller derby's logo. And in the complaint, the guy very pithily says, the lawyer, I mean, they don't even have any more creativity to come up with a logo that doesn't look like our logo. It's a heist in plain sight.
Ooh, all right, we'll see what a judge says. Sarah and Bob, thank you both.
Thank you, Shannon.
Thanks, Shannon.